Hi, everybody. It's Yoli Medina, and I'm going to be talking about the Kohberger case. And this is a case where Bryan Kohberger pled guilty to the unalivings of 4 students: Maddie Mogan, Xana Carnodal, Ethan Chapin, and Kaylee Gonsalves. They were students at the University of Idaho, and they lived in a home that was close to the University of Idaho. It was a private rental home. So Bryan Kohberger pled guilty, and he waived his ability to appeal. And it turns out that waiving your appeal rights doesn't really mean waiving your appeal rights. So there are certain things that Bryan Kohberger can appeal, and the judge, who is Judge Hippler, made that a point at the sentencing hearing, which probably confused everybody. And so from a civil standpoint, because I practice civil law, I understand the point that anybody can file a notice of appeal. And so a notice of appeal is different from the opening brief on appeal. So regardless of what kind of plea agreement the defendant had, the defendant has a right to file a notice of appeal. And that is a document that is filed and puts the lower court, meaning Judge Hippler's court, on notice that there's going to be an appeal. And it puts the appellate court on notice that there's going to be an appeal. That is not the opening brief. It's not anything like that. And the court clerk, the appellate court clerk, cannot reject that notice of appeal. So keep in mind that if a notice of appeal is filed on behalf of Bryan Kohberger, that doesn't mean that an appeal was actually filed. So after the notice of appeal is filed, and I believe Bryan Kohberger has 42 days from the date of the judgment was entered to file a notice of appeal. So then the next step is the appellate brief. So Bryan Kohberger can put all the bases for his appeal in the opening appellate brief, but that doesn't mean that it's going to go anywhere, because the prosecution will bring to light that there was a plea agreement where he waived appeals. Now, there is the Garza case that is on point in Idaho. And that means that if Bryan Kohberger asks his defense attorney to file a notice of appeal and she does not, then that automatically deems his counsel as ineffective assistance of counsel. That was the issue there. However, there are certain things that can be appealed, and they're very narrow. That's my understanding. But there are a lot of criminal defense attorneys who have put out their thoughts on whether or not Bryan Kohberger can appeal and what the likelihood is of success. So the notice of appeal does not mean that the appellate brief was actually filed. So just keep that in mind. That's the best I can say. A notice of appeal is filed, and then you wait for the appellate brief. And then you see the basis for which the appeal is based on. Now, in the Kohberger case, there are some unique things with this case. One is that there is an investigation into the leaks which led to the Dateline episode, which contained erroneous information. It contained accurate information, but it also contained erroneous information. And the prosecutor, Bill Thompson, and the other prosecutors who assisted in the case said that there were erroneous things in the Dateline episode, which could have affected the outcome of the case. Now, that's one specific unique thing to this Bryan Kohberger case. The other thing, and actually, the Idaho Statesman has produced an article, and I'll try to link it to the in the description box what that article was about, but it was about the leak and that there is a special prosecutor assigned to investigate the case. It's confidential unless somebody is charged with the crime of violating a court order. Then we will know about it. If there isn't anybody charged, then we won't know about it, which is, I don't know. But in any event, the other issue is that Bryan Kohberger has been diagnosed with autism spectrum disorder, obsessive compulsive disorder, and some kind of neurological movement disorder, coordination disorder. Now, this is in the record, the court record. And one of the problems in this case was that the judge would seal the evidence attached to motions, but wouldn't seal the motion itself. So some of the information that was attached, that was sealed, trickled into the motion because, after all, you're arguing evidence, which is attached to the motion. But that's a problem I've always had, is that it's half and half. It's like in some of the motions, the evidence would be people testifying, and that would be sealed. But then the actual argument on the motion would be open to the public. And so how do you argue facts that are sealed when you're arguing in a public hearing? And in those types of situations, I find it prejudicial both for the prosecution and the defense. So when Ann Taylor filed her motion regarding Bryan Kohberger's diagnoses and how she wanted to be able to instruct the jury that Bryan Kohberger had autism and he had a straight, cold, non-expressive type of face, the judge denied it because the jury is only supposed to take into consideration what comes from the witness stand. Now, if Bryan Kohberger was a witness and decided to testify, then she could bring that instruction in. But if he's sitting at the counsel table, there is no law. There's nothing that would allow the judge to allow Ms. Taylor, his defense counsel, to instruct the jury that he has this, stone cold face and it's part of his autism spectrum. So in any event, so the issues I have is whether or not the judge should have addressed his disabilities and his psychiatric disorder at the plea hearing. So when Hippler, he asked Bryan Kohberger whether or not, he asked him, "Are you of sound mind?" And Bryan Kohberger said yes. So that may encompass part of it, but I am just thinking to myself, did the judge have a further obligation, since there was evidence in the record from mental health professionals who had diagnosed Bryan Kohberger as being on the autism spectrum disorder, having obsessive compulsive disorder, and some kind of neurological coordination disorder. So I question whether the judge had an obligation to ask Bryan Kohberger, are you aware that you've been diagnosed with such and such? And Bryan Kohberger would say yes, hopefully. And then the judge would ask, are these diagnoses in any way affecting your ability or affecting your decision to plead guilty in this case? And I would like to know the answer to that, because obsessive compulsive disorder is an anxiety disorder. They have intrusive thoughts, compulsive behaviors, and in reading the documents that have just been released by the Idaho Police Department, one of the interviews with one of the people who were housed with Bryan Kohberger in the cell next to him was annoyed. He said the only thing that was annoying was Bryan Kohberger's habits. He would wash his hands like dozens of times a day, take long showers. Well, those are indicative of obsessive compulsive disorder. And these people who have obsessive compulsive disorder, they need certainty, that they can't handle uncertainty. And so it could possibly have some kind of effect on his pleading guilty, just to just relieve the anxiety, because obsessive compulsive disorder is an anxiety disorder. So those are the things that I question, and I try to ask these things when certain channels have criminal defense attorneys on their panel, and I try to ask about the OCD, obsessive compulsive disorder, because people focus on the autism spectrum disorder and they say it's not an intellectual disorder, it's a social disorder, and I agree. Bryan Kohberger had a social disorder. He was awkward. But the obsessive compulsive disorder is a psychiatric disorder. And it seems to me, well, strike that. I just heard Nancy Grace having a mental health professional on the show that said, yeah, Bryan Kohberger is going to suffer because he sounds like he has obsessive compulsive disorder. Well, he does have obsessive compulsive disorder, and it's in the court record. So she said, but they'll medicate him. Well, not necessarily. He can refuse medication. And based on what the prisoner that was next to Bryan Kohberger that said he was constantly washing his hands, it sounds like Bryan Kohberger is not medicated. He can refuse medication. So whether or not that should have been asked by the Judge Hippler about whether or not that would affecting his decision to plead guilty, whether or not that should have been asked, I don't know. But it is a psychiatric disorder, and it is in the court record. Whether you believe he has that or not, it's in the court record. It's evidence in the court record. So those are my thoughts on what's happening here. And I think that Bryan Kohberger certainly has a right to appeal, and the notice of appeal could be filed, but that doesn't mean that he's going to win it. And I know one thing for sure is that he can file a notice of appeal and an appellate brief based on ineffective assistance of counsel. There are other things that are unique to this case. Like I said, there's a special investigation going on regarding the leak to Dateline. There's also the fact that he's been diagnosed with certain disorders, and those were not addressed at the sentencing hearing or the plea agreement hearing. And so those are things that I have questions about. So to answer your question, yes, Bryan Kohberger can appeal. He can file a notice of appeal. He can file an appellate brief, but it depends on what his appellate brief is based on, whether or not the court will hear it. And the chances are slim, but not impossible. But that's my understanding. So in any event, let me know what you think. And I hope I helped in trying to understand this appeal thing. So I hope I didn't make it more confusing. In any event, thanks for watching.